Chigwe. Kitegeeza ki Dr. Besigye muyita mu kooti.
Kankole. All right. Ladies and gentlemen, as you see, picture Sonyiwa atola ko inamu village balwa choka deployment eriwana ye mune eriwana for corruption nze wembadde obuyinza atandise dde omusajja abaddeko ne mundo. This is what is happening.
You're talking about Chimakwata.
Nina emirimu egy'okukola wali ku anti-corruption. Ojja charge nina emirimu egy'okukola bro. Adolf. Soko ove mu kamera yange vaayo mu bifaananyi. All right. Hello. I'm good. How are you doing? Amina wamuteredde mu ddonga lyakwesibyeko senfuna obedi naye byajoka ku bifaananyi. Let me show you. Good morning, Afande. Sama Uganda media so kwezo embera kweli kubanga tutambula Uganda bange koti yakomyewo koti
We shall specifically now address you on the second link of our application, which is about an order of release, unconditional release. Dr. Besigye together with obedi, and this is grounded on the provisions of section 38A, where this honorable court is called with jurisdiction and powers, my lord. Situations where the applicants are incarcerated without any lawful orders to, my lord, grant an order of unconditional release. And this is the provision, my lord, that the High Court may at any time where a person is deprived of his or her personal liberty otherwise than in execution of a lawful sentence or order imposed on that person by a competent court upon complaint made to the High Court by or on behalf of that person. And if it appears by affidavit made in support of the complaint that there is a reasonable ground for the complainant, court is given powers to give award and so on and so forth. The gist of the matter, my lord, is about court being satisfied that a person before court is detained without lawful orders. My lord, these facts are brought out in the affidavits.
Before you proceed, I think the AG or the representative of the court can he formally be on the court? Or if I have seen badly, then we can proceed.
Also, Brad,
the microphones are set. You can speak from there. We have many lawyers. So.
My name is Johnson Latwera. I'm a senior state attorney. Together with Matthew Mohesi, the state attorney, and Jacqueline Amsable, the state attorney. We are lordship. We are sorry we are late because this matter was served on us late, and we had to ensure that we respond. We have filed our response and an estimates, and we are ready to proceed.
How many minutes do you need?
My lord, on my part, I think 10 minutes would be enough, and then my colleagues will also come.
Apologies to the Attorney General's chambers. It's not our name. There is some taken over the court.
No, you were supposed to ask him why you're not
My lord, it's our prayer that you will be pleased to find that Dr. Kizza Besigye and obedi lutale are in illegal incarceration, given the fact that, my lord, there is no evidence before you that there is any charge referred against them, or that there is any remand warrant being issued by any court, or any lawful order given by court for the authorities in New Zealand to keep them in custody. My lord, the affidavits which are borne out, the facts which are borne out in the affidavit of the Honorable Winnie Nima, as well as counsel Proscopia of the hearing, are uncontroverted. There is no any evidence from the respondents, that is the Attorney General and the Commissioner General controverting that evidence. And in section 57 of the Prisons Act, my lord, section 57 is very clear. Of the Prisons Act, 325, a person shall not be received or admitted into prison custody without a valid commitment or remand warrant or order of detention, warrant, conviction, or control. So that is the law, my lord. And now, my lord, the essence of habeas corpus is well explained in the decision of this honorable court in miscellaneous code number 16 of 2021. Honorable Chakulani Sentam Robert, Babula Chakulani Tungo versus the Attorney General and the Chief of the Defense Forces. On page 14, my lord, a copy of which is going to be supplied to the court. Section page 14, this honorable court had the occasion to succinctly explain the essence of the writ of habeas corpus in the following terms. The purpose for a writ of habeas corpus ad sub judicia is to review the legality of the applicant's arrest, imprisonment, and detention, and challenge the authority of the prisoner or jail warden to continue holding the applicant. The application is used when a person is held without charges or is denied due process.
Okay, can we stop them, counsel?
Yes.
How did they end up in prison in the first instance?
My lord, that is for the Attorney General and the Commissioner of Prisons to explain by way of evidence.
So for you, you have no idea.
My lord, I'll explain.
Yes.
My lord, initially there were charges that had been preferred against them as explained in the affidavit of Winnie Yanima and the Proscovia Bonihira. My lord, that is well explained. If I may go there, my lord, to read the relevant paragraph.
What is the explanation?
The explanation is that, my lord, the defunct General Court Martial had preferred the charges against them. And on the 31st day of January, my lord, this year 2025, the Supreme Court unequivocally
Thank
What happened, my lord? All the proceedings before the General Court Martial were quashed by the Constitutional Court, and my lord, the decree to that effect was extracted.
Do you have it?
My lord, I'm sure it's on record, my lord.
But do you have it? We take us step by step.
Yes, my lord, we will be granted more time for certain things I had associated before, because I don't know what other ways necessary from this matter.
Still, we have members of the media. This is very important for them to hear what the Supreme Court says.
My lord, it is hereby ordered that the declaration of the Constitutional Court that section 119, subsection 1G, now section 117 of the UPDF Act, which provides that any person not otherwise subject to military law, who aids or abets a person subject to military law in the commission of a service offense, is unconstitutional. So that order is hereby set aside.
Now, in one
Two,
line, in one line, what is that paragraph state?
my lord, initially the Constitutional Court had held that section 119, which is now 117, that had provided for a situation where civilians would be subject to military law if they abetted the commission of an offense by a serving officer, that was a valid law. they had not nullified those provisions. Now, that order of the Constitutional Court was set aside by the Supreme Court, meaning that Section 117 has now been nullified by the Constitutional Court.
Next paragraph.
All charges, all ongoing criminal trials, or pending trials before the courts martial involving civilians must immediately cease and be transferred to the ordinary courts of law with competent jurisdiction.
No, before you go to 3,
Yes.
one line give us the essence.
All charges, my lord, all charges, these charges are preferred by the DPP under Section 100, Article 120 of the Constitution. The charges before the General Court Martial are not sanctioned by the DPP. So the charges to be taken or transferred to the civilian courts pursuant to this particular order are those ones sanctioned by the DPP. As we speak right now, there is none, my lord. There is no charge sanctioned by the DPP to be taken to the civilian court.
So, but in a sense, the decree indicates that there is a certain code, not the civil code, not the civil thing. Is that how I understand?
That they can, yes, my lord, a court of competent jurisdiction.
So, address us very briefly whether I am a court of competent jurisdiction. Deal with that.
In regards to taking bully, this is not a court of competent jurisdiction. But in regards to the matters before you, habeas corpus addis abducienda, we are in the right forum, my lord. Yes.
Paragraph 3.
This judgment shall have no retrospective effect on any conviction made and sentences imposed prior to the date of this judgment, save where the conviction and sentence is being challenged in a court of law. And this is not applicable to the applicants because they are not convicts. And finally, my lord, no, the second last one. All pending trials or partly hard criminal cases that fall under the civil law court's jurisdiction, which are against members of the UPDF who are subject to service law, must be transferred to the civil courts with competent jurisdiction. It's also not applicable for the serving members of the court. 5. Save for the issue of the establishment of the General Court Martial as a court of law, this appeal fails and is hereby dismissed. That is
So, very briefly, how many paragraphs are applicable in the motion before this court?
my lord.
Under that decree.
It is, as far as the matter before you is concerned, it's paragraph 1. Only paragraph 1, where,
Focus on that.
all right, my lord. My lord, the submission is that following this declaration or pronouncement by the Supreme Court, the proceedings hitherto pending before the General Court Martial under Section 117 of the UPDF Act became inactive. They were quashed, and there are no proceedings pending against the accused person. And that brings us within the realm of the prerogative order of the writ of habeas corpus. We have already cited Section 57 of the Prisons Act, and also now the Section 38 of the Judicature Act. But now we are addressing you on the issue of curtailment of liberty and the remedy that court is enjoying.
Do you intend to make written submission?
No, my lord, we are given the nature of this matter, my lord, and the circumstances concerning the dire state of our trial, particularly Dr. Kizza, his health status. We deemed it imperative that
Now,
my
at least I can go on record. What was being thrown around the media, it just seems to be an we better.
No, my lord.
So, I'm really clear that what has been written about his status is a bit different. 1 minute, the Lord Mayor.
3 minutes, my lord. Most of that, my lord. My lord, I have already addressed you on the question of liberty under the authority of Chabula and the Barbara Chongo. One aspect which I needed to point out in this particular document is still on page 14. Liberty is defined by Black Law Dictionary, freedom from arbitrary or undue external restraint, especially by government. And this is, my lord, the import of the spirit of Article 23 of the Constitution, which guarantees liberty of Dr. Kizza Besigye and obedi lutale. In this particular case, my lord, under Article 23, first of all, they have not been informed of any offense under which they are, which they may have committed, and the reason why they are in Lucia, and there is none. Two, my lord, Dr. Besigye has no access to a personal doctor right now for proper medical examination. And that is a very serious matter, my lord, because in as much as by a cursory look here, one can make an observation that maybe is improving. My lord, his state, the circumstances compare that an order be issued for Dr. Besigye to regain his liberty, to be able to access a medical facility of his choice, so that he can be thoroughly examined to assess his health situation and get proper specialized treatment. My lord, the final authority I would like to cite on this one is Tuanka John and others versus the Deputy Director General of Internal Security Organization. It's miscellaneous cause number 9 of 2021, where again this honorable court has decided that a writ of habeas corpus applies in cases of illegal detention and is meant to secure the personal liberty of a person under such illegal detention upon determination of the validity of such detention by the court granting the writ. I agree with the counsel for the applicant that preservation of personal liberty is crucial and should only be derogated from in exceptional circumstances where there are court orders, and that is the position of the law. So this particular law, my lord, is reinforced by section 15 of the Human Rights Enforcement Act. My lord, and this is where we are grounding our prayer. Section 15 of the Human Rights Enforcement Act of 2019.
Maybe to share some information with you, counsel, there is a separate application grounded on the enforcement of human rights by a number of lawyers, and that file is before another judge.
Most of that. So let me not go there. Let me sum up my lord, my submission under section 30. My lord, it's our humble prayer. Now that the Attorney General and the Commissioner General have not in any way attempted to justify the incarceration of Dr. Kizza Besigye and obedi lutale, my lord, you be pleased to order for their unconditional release, and specifically for Dr. Kizza Besigye to be able to access the medical facility of his choice, so that he can be attended to by physicians of his choice.
Is it your case that I should make that order now?
This is the prayer, my lord, that the order be made today and now, under the circumstances. And that's what a writ of habeas corpus is all about. Any continued detention, my lord, would be again a further violation. And we would want to see this honorable court abusing in the violation of the rights of the accused person. And for one thing I need to emphasize, my lord, there is the 48-hour rule, which is very, very crucial and imperative under the Bill of Rights. So you can only curtail one's liberty within that period of only 48 hours. And to date, since 31st, Dr. Besigye obedi lutale have not been taken to any court to face any fresh charges whatsoever. So we pray that, my lord, you be pleased to invoke the powers here, grant the prerogative writs, and have Dr. Besigye and obedi lutale released. We do so from our prayer.
Like I said, he's my former teacher, so we are trying to be nice.
My lord, maybe to just make two very simple points. It appears that this writ
the matter before you is being constructed around the decision school. But before we even arrive at the decision, I think there are two simple points that must be made. Personal liberty can only be curtailed on the basis of some lawful order. That lawful order cannot be verbal. It must be documented. It must be demonstrable. Otherwise, the curtailment of that liberty is unlawful. And because of that problem, the unlawfulness of it, that's why we have this writ in Article 24 as non-derogable. This writ has not always existed. The 1967 Constitution, it wasn't there. But from the case of Besigye was 1966. It was recognized and changed into the 95 Constitution. It wasn't a case of, the common thing where people sort of disappear in policy. It was known where he was, just like it is known where these applicants are. In fact, we need not say much because when they came here, they were in the company of other officers of the state who have a unique attire. So we were able to tell that they are in custody. We knew.
I keep reminding our journalists, please don't involve me in your the main focus.
So the first limb has been satisfied. That limb is bring the body. Sometimes we equate it to whether dead or alive. The body is here alive. You have to escape. But the second limb is what my land friend has been addressing the court on. The reason for curtailing the liberty of those individuals. My Lord, the Supreme Court did not say that those who are incarcerated should remain incarcerated, except for those who had been convicted. One might argue,
for example, I was thinking we needed to consolidate these two applications. So you are saying for friend kizza, since he was convicted, so the writ has...
That case is actually different, and you will note when it comes out. Those who have been convicted, unless they are not challenging the conviction, I believe my land friend is very vigorous challenging the conviction. So there is nowhere in the judgment where it was said those who are in detention stay there until such a time that the government decides that it will find a competent court and transfer those files. So this application is brought with that idea, my Lord, with that argument in mind.
I wish we can get a chair for the AG staff. They need to write some of the things. They can't write.
They didn't respond. They didn't respond. If they didn't respond, they...
They've responded. You check and see
I don't know why they pay. If they respond in 7 days.
Private lawyers have taken over.
We pay them when we prepare. Of course, we are doing. You might be fine. Hear him.
He's supposed to be a lawyer.
My Lord, I'm only concerned with the statement that private lawyers, we are not private lawyers, we are your officers.
I apologize.
Thank you, my Lord.
Your officers of the court.
So, my Lord, one of the orders that was made is that these trials cease and be transferred. In there, they could have argued, cease, the detainees remain in custody until the cases are transferred. They did not do so, and they were wise. Because they had just pronounced themselves on the illegality of the basis of those charges before the court martial. So, my Lord, as we speak, there are no charges pending anywhere in Uganda or elsewhere, apart from a case in Buganda Road on which the first applicant is on bail. His bail is being extended, but he goes back to another location. That is the only one that is pending. But in that one, his liberty was given back to him. My Lord, the burden to justify the reason for detention, for curtailing person, is not on the one who is applying. My Lord, you can see that the affidavit was not even sworn by the one applying. The burden is not on the one applying. The burden is on the state.
And the state has
The
replied.
state has replied. I'm going to address what it was saying. There are two aspects involving the state, two places where the state has responded, in my view. One, the prisons officers would have brought before this court a warrant saying Court X on date Y told us to keep the body of these individuals until we go back. I have not seen it in the response. The second possibility would have been that they are pending charges, and this is the charge sheet. I know those pending charges can't come from a court martial. Because some of the offenses in the UPDF can't be tried in the civilian courts. There are offenses there that are very different, of a very different character, and they don't exist in the penal code. They can't be tried in these normal civilian courts. So they would have brought a charge sheet which says, you in court X, they are pending charges. This is the reason why these people are. What do they refer to? They refer to the Supreme Court decision, which did not say keep them in.
Maybe it's the AG will have to carry
So
the cross.
I want to submit, my Lord, and I hope that you will be persuaded that the response from the Attorney General falls short of justifying the reason for denying the applicants their personal liberty. Since the 31st of January 2020, it says nothing to you, my Lord, that explains why the liberty is curtailed. It only says the Supreme Court said transfer. But as I have shown you, some of these offenses
Cannot be transferred.
transferred, but that may not be a matter for us to investigate. But they can't be transferred. So it is our contention, my Lord, that a proper case has been made out by the applicants for this court, which is clothed with that power. Because the power is unfettered. It is so unfettered it can be applied immediately. Clothed with the power to order the release of these applicants today, if the state has a lawful reason, let it act lawfully after those orders are issued, to then deal with the issue, whatever the issue is. My lord friend has made reference to section 15 of the Human Rights Enforcement Act. I am aware, my lord, you are perfectly familiar with that space, and I very respectfully urge you, my lord, to find merit in this application and grant orders that have been sought. My lord, my land friend, Honorable Sekona, wants to just wrap it up.
How many minutes, Honorable?
My lord, I will request for only 2 minutes. Except that I will request that the officer obstructing your view of my body language. You were told that you need to look at me. My lord, just to sum up, section 57, which has been cited by my land friend, Honorable Elias Ukwa, is instructive. A prison's officer can only detain on a valid warrant issued by a competent authority, in this case, court. Upon the demise of the General Court Martial, it is very clear that the power of the General Court Martial to order detention collapsed. And it collapsed in the presence of the Attorney General of the Republic of Uganda, who is the first respondent in this application. Whereas it is urged by the first respondent in the affidavit of Mr. George Kalemera, paragraph 9, that the Supreme Court did not order release. There was actually no necessity to order release.
So, yeah, on that point.
Yes, my lord.
So you are trying to read in some words in the decree.
No, my lord.
It was not necessary, but it said so in so many words. You are reading it.
I am not even wanting to go there. I am only restating the position of the Constitution. Under the Constitution, liberty is guaranteed. Restriction must be justified, and that justification must be a lawful one. And in this particular case, the lawfulness would only be cemented on an order on a valid order of a court with competent jurisdiction. In the absence of it, there is no justification, and it is your power, my lord, and duty to order freedom to be reinstated. Away from the Prisons Act, my lord.
Because some people, your colleague, the Lord there, my former teacher, are putting me under some weight that I should put now. What I need to write it, do I write it?
My lord?
Can you address that?
Yes.
I can write it?
Yes, my lord. Yes, my lord, now is contextual. And what we are saying by now is that upon conclusion of our submission, the court be pleased to begin writing the release order. In the same realm of context, my lord, I now propose to take you to the context of the Supreme Court's order of transfer, which has been misconstrued. My lord, this must be looked at from the perspective of Article 120 of the Constitution. The Supreme Court for judgment given at the time of the hearing that is the context of we propose and implore you find pleasure in ordering release now. But this particular case of Kageni versus Musilamu was cited with approval in Rose Wanjiku Njau. Rose Wanjiku Njau versus Nicholson Philip and 2 others. Miscellaneous criminal application number 387 of 2012 by the Supreme Court of Kenya. To sum up, my lord, in one sentence, the affidavit of Mr. George Karimera, which attaches a letter purportedly by the principal judge, and now you can see the bad faith, exchanged without reference to us, particularly those of us who went to the Supreme Court, does not place a lawful justification. It only talks about the administrative measures.
For the benefit of our media houses.
Yes, my lord.
Just give the essence, because you have made reference to that later.
Yes, my lord.
Essence of the honorable principal judge's statement. What is it in this statement?
My lord, in principle, the honorable principal judge is communicating measures taken by the judiciary administratively to guide the process of moving these files away from the deceased court martial.
Let's bullet those measures. We can speak about 3 measures in a bullet form.
No, my lord. The principal judge, and it is that order which would have been the justification to restrict somebody's freedom. But let me ask a question and answer it. Thank you, my lord. That's so gracious. On whose orders and under whose authority are the applicants in detention? Number 2, what is the criminal case number? The Supreme Court having said the prosecution ceases and with immediate effect by 31st. By fall of night 31st, the criminal case number for the general court martial ceased. The file could be there for investigation purposes. You and I could be, maybe not you, maybe I could be under investigation. God forbid, you should not. We need you. So the question is, under what criminal case number? And detained until when? The last time we had a detention which is unlimited in duration was under the Public Safety Act. And that one collapsed with the coming into force of our constitutional regime. Nobody can be detained indefinitely where there is no pending charge. That one will be a recipe for chaos in our country that anybody would detain. With that, my lord, I can only say that let nobody drag the judiciary into this detention controversy of, say, relying on the order, the letter of the principal judge, an administrative letter.
But it's already drafted. I think
very unfortunate.
ironically, you cannot run away from being dragged in.
you do the right thing.
My Lord, if we are going to construe this as authority, the letter of the PJ, the next thing they will request you for a letter of granting a warrant to detain. And this was not a judicial letter.
I understand.
It was an administrative guidance to those persons, if they are still interested in prosecution. Anything beyond that, my Lord, is a persecution, and I would invite you to put a hold on it. I so pray.
You know, the lady has been standing. I'm not really the AG's lawyer, but I'm dying to listen to the AG's.
My Lord, in a minute.
You are my classmate. I'm giving you.
My Lord, in 1 minute, Samuel Zemolienga is my name. I'll just take you to Article 43 of the Constitution, my Lord, where you cannot detain anyone without trial. There is no ongoing trial, my Lord. Secondly, everything about that defunct General Court Martial was nullified. We cannot continue discussing putting something or nothing, my Lord. And an administrative letter, whether by the Chief Justice or Principal Judge, cannot be such authority to take away this provision of the Constitution, my Lord. My Lord, Father, my colleagues have submitted about Article 123, my Lord. If you look at 123B, my Lord, actually, my Lord, to conclude on the letter, to correct my statement. Our statement, when I look at this letter, it is by Chidewa Chiwanuka, not the PJ.
Actually, I apologize because I got a soft copy. I've only seen this physical copy. I withdraw the application. It is the Attorney General. I only got a soft copy here.
My Lord, to conclude, reading Article 123B, even the DPP, my Lord.
Hold on. When you say the letter is by
Chidewa Chiwanuka.
you mean the Honorable Attorney General?
Yes, Honorable, my Lord, Honorable by designation, but I knew that this court would take judicial notice of that, my Lord. Finally, my Lord, my reading of Article 123B actually precludes the DPP from even taking up any matters from the court-martial. It is very explicit. So most of the submission and the affidavit evidence that I've seen from the Attorney General is misconceived to the extent that it believes, the Attorney General believes someone can be in detention on orders of the Attorney General. My Lord, I join issues with my colleagues. Probably the rest will come in rejoinder. I'm obliged, my Lord.
Thank you very much. I think that's all. Except I also wanted to listen to the there's been a lot of story in this court, particularly I mean, we love it when people express their minds, but you have to do it. Don't get. Well, if I'm short, I die once and I will be buried, but then you will not have paid anything. So probably your client's matter would have gone before another judge and that's a whole man. So appeal to your audience, put it down. That is the Fortunately, I don't take the line that you insult me when I get you on court. I love you. They can insult me, they can but don't extend those insults. Threats. That's about housekeeping. I want the point is made. Can't hear this.
Leonard Push.
So, how you reply to the application?
Yes, my lord.
So you listen the comments of the arguments. Can you take us back point by point why you oppose the application?
My lord, for record, again, I'm Johnson Aquera, and I'm a senior state attorney. My lord, the application before you and as well is for habeas corpus. And for habeas corpus, it has elements that you must prove for it to be granted. One is that the person or the applicant was arrested. The said applicant is in detention, whether by state or anyone else. And that the detention is illegal. It's not in contention that the applicants were arrested and are in detention. The only issue is whether their detention is legal or illegal. And it is our contention that their detention is lawful. Your Lordship, we are not here to review the Supreme Court decision.
Let me go slow. So we are on the lawfulness.
Yes.
Point number one, bullet one is this court cannot review the Supreme Court decision.
Absolutely. And this is not the purpose of this application. The Land Honorable Chief Justice wrote about 200 pages. The application or the judgment of court cannot be construed in the way they feel it should. They apply the same court that issued it for clarification. My Lord, I'm not here to impose words, interpretation, because I'm not qualified to interpret the judgment of the Supreme Court, otherwise expressly given. Yes, and that's what I've said. I'm not here to interpret otherwise as expressly given. Your Lordship, my boss, the Lord Mayor, who is part of this government, has elaborately read through the orders of this report. And if any case will be on my side, defending government. He has elaborately read through the order of the court, dot by dot, word by word, and nowhere did the court say release. It only gave an order of transfer. Transfer all the files which are pending before the court martial to court of civil court. And from our affidavit, I can only take a brief that on 31st January, the Supreme Court indeed gave that judgment. Most importantly, the court ordered that all charges or ongoing criminal trials or pending trials before the court martial involving civilians must cease and be transferred to the ordinary courts of law with competent to fulfill and implement the order of court. On 3rd February, government commenced the implementation. We wrote the Chief Justice, the Land Attorney General wrote the Chief Justice requesting for a liaison contract on how transfer of files can be managed. On 4th February, the Chief Justice appointed the Principal Judge as the liaison contact and instructed him that all matters should be handled by himself.
So, if I now sit here trying to listen to these topics, I have superimposed myself on the role of the principal judge.
I'm coming to that now. However, I didn't want it to push it into your mouth.
No, you can.
But since you have already said it, my role, I take it, and that is the position of the respondent. And on 6th February, my lord, the Attorney General forwarded the Chief Justice's instructions to Minister of Defense and the Office of DPP. And on 13th February, that's when we received a decree from the Land Council for the Africans in the case of Kawazi, not the respondent, in the case of Attorney General Batas Kawazi. And on 17th, the same was signed by both sides. My Lord, Article 28 refers to fair hearing and a speedy trial. Speedy trial and fair hearing is not one-sided. It is both parties. In this case, the applicant and the state. The state has taken action to implement the orders of court. The orders of court are clear. Transfer the file. And it's not in contention that indeed the applicants had been charged at court martial and they had been remanded and there was a warrant for their remand. If the Supreme Court wanted to cancel the remand warrant, wouldn't have taken a paragraph after almost 200 pages to mention so. It only say transfer the file to ordinary court. And that's what the state is doing. It will be contempt of court, the Supreme Court. For this court or the other one, and also if Attorney General had not acted the way he has acted. The fact that the Supreme Court ordered transfer and did not nullify or order release all the accused in the court martial. And for your information, my lord, it's not the applicants alone who were for the court martial. There are many. The fact that there is no order on court records. I have had my land senior colleague, Honorable Segona, trying to explain what is not in the judgment of the Supreme Court. I don't know whether we have different copies for the same judgment, but there is nowhere where the Chief Justice said otherwise, apart from transfer. And if he wanted so, he would have mentioned. The fact that the Supreme Court did not say release, it was aware of what it was doing. And in that so, it validated all the orders that all the suspects are based on to be in prison. If it had been otherwise, a sentence of saying release, actually that word alone, release, would have been enough. But if there is any person that misconstrues the judgment of Supreme Court, the right forum is the Supreme Court. As an officer of this court, Honorable, I need to guide that do not be misguided by my land colleagues from the other party.
Correct you. It's not like them that you and allow them.
Most surprised.
That's why we are done.
Most surprised. And I'm alive to the fact that you are a doctor in law.
Okay, let's not go there.
So there are three parties in this circumstance, my lord. For the misinterpretation of the Supreme Court decision, it would go back to the same court that issued the same order, what it meant by saying this. It is in the interest of the state and for the people of Uganda that justice is done on both fronts. The biggest issue.
What the lawyers on this side are saying, okay, fine. You are doing something. How long must this wait? And you want to address it?
Yes, my lord. I will not accuse the Supreme Court that it is to give us a timeline. But however, from the reading of our evidence, the judgment was given on 31st January. Immediately, on Monday next week, which was Friday, we acted, and the process is ongoing. We are not going, I cannot mention how many files are involved, but they are numerous. And the process of expediting the process is on course, and that's why the principal judge was allocated this responsibility. It would be premature and unlawful.
There is an allegation of slow speed on your part. It is because of the volume of work you have
Absolutely.
and not that you are
Absolutely.
correct.
And it would be justice, my lord, to say that slow speed. For example, this application was served on us last evening, around 9 p.m. There is an accident on record. I didn't sleep. My team did not sleep. That General did not sleep. I was on phone up to midnight to respond, to ensure that justice is served on both fronts. My lord, in conclusion on my part, this application is misconceived because the applicants are aware that they are in detention legally, and the state is not denying where they are. And at any time you want to look at him, you can even visit him, anyone can visit him. And if anyone want him to be produced in court, can be produced in court. But ordering his release would be in contempt of the Supreme Court decision. I saw submission.
I would like to associate myself with my colleague's submissions, and I just want to emphasize that as has been rightly submitted by my former teacher, my Lord, Council Karibala, that yes, one of the orders, one of the conditions has been fulfilled, and that is the production of the applicant. Now, the other issue would be the lawfulness or whether or not legal or legal detention. Lord, I want to emphasize that we should not read into the judgment of the Supreme Court what it did not provide. This was a decision of the Supreme Court not sitting as an ordinary court, but as a constitutional court. And my Lord, as the highest court of the land. Now, my Lord, as officers of the court, we need to respect court orders. And for the applicants to come to this court and read into the court's decision that the warrants that were given by the court-martial have been invalidated is a very serious misconception, my Lord. Our submission, my Lord, is that the applicants are in lawful custody. And why am I saying that? I would like to make reliance on an authority of our versus governor of Brixton Prison.
Instead of going there, why don't you discuss it here? Because where it was no. But the court went ahead
in fact, my Lord, I am trying to justify that we are holding the applicants in a lawful way, or we are having them in lawful custody, supporting what my teacher was saying, that we should justify that we are holding him in lawful custody. And in this decision, my Lord, it's called R versus Governor, Brixton Prison, Pate Ama. My Lord, the House of Lords was examining whether a detainee held under extradition proceedings could be released via habeas corpus, despite procedural irregularities. The court held that even where there are procedural errors, detention remains lawful if there exists a valid substantive basis for the person's confinement. The emphasis, my Lord, is if there exists a valid substantive basis for the person's confinement. My Lord, this is the valid.
Do you have that experience?
Yes, my Lord, that's right. Now, my Lord, in this case, Officer Besigye, the applicants here, were arrested and charged with various criminal offenses, including prison, my Lord, which justifies their pre-trial detention under Ugandan law. The fact that this case was initially handled by the court-martial does not negate or does not invalidate that we had valid reasons, my Lord, to detain them. And my Lord, the Supreme Court, well aware of this, simply said, transfer them to the civil court. Our submission, my Lord, is any argument about a warrant being not valid can only be made after the process of transfer has been completed. And this will happen before the criminal court, which is going to handle this matter. My Lord, it is very misconceiving and misleading for this court handling a matter for habeas corpus to go into questioning the validity the warrant, which is the basis for which the applicants are saying they are holding him illegally. My Lord, that is not the purpose of habeas corpus. We are praying, my Lord, that you be persuaded by this decision. And my Lord, we have highlighted the relevant facts, and you will notice that the court said, the court actually said that you should not question, that the question then arises, what should be the proper approach by the court in determining any such inquiry is maintained. Of course, the authority on which the lower holds the applicant is the authority of the court. The court martial was the court at that time. Can only, and it is still the court, can only be to see whether the court, this is what this court says, can only be to see whether the court had worked the court there, entitling them to issue the authority, the warrant. This is what we are telling you right now, that we had valid reasons to detain the applicant. So to argue right now that the warrant is invalid, it's not proper before you, my Lord. And on that basis, my Lord, we pray that this application is dismissed for being premature. We have clearly stated to you through the affidavit of Judge Kalimera the processes that the Attorney General has taken in compliance with the orders of the Supreme Court, not outside the orders of the Supreme Court. My Lord, we pray that you have persuaded that our submission has
at least we know the company, we know the animal. Yes, what we already know. So you can highlight maybe in 3 minutes what you really
My Lord, on the contention that the applicants are in lawful custody, my Lord, we are really disturbed by the justification given by the senior state attorney here, reading too much into the Supreme Court decision. He is suggesting that by ordering the transfer of the file, by extension, the remand warrant was extended. That is, if I got him well, correct. That is unacceptable. He reached a point of suggesting that if court held otherwise, it would amount to contempt of court. If this honorable court held otherwise, then it would amount to contempt of court. We take exception on the following grounds. One, my Lord, the Supreme Court was categorical in its direction. And if they wished in any way to save any order of the defunct General Court Martial, they should have said so. If in any way they deemed it necessary to keep the applicants on remand pending transfer of the files, they should have expressly stated so. It's nowhere stated in the orders. My Lord, the Supreme Court went ahead and gave structural interdicts in regards to areas of amendment to guide the Parliament. If they could go out of their way to guide the Parliament, if they have come up with a new legislation, the parameters, the principles. How about on the issue of remand, if indeed they wanted the applicants to remain on remand pending? That is one too.
No, before you look that.
Yes.
The way I understand this the court will say you have to do ABCD within 6 months or 1 year. If you don't do it within that time, we shall do it like for you. And the wording shall be like ABCD. That is how I understand the structure. Is this what the Supreme Court said?
No, that is for the legislative process. It was structured. But for declarations, my lord, they have to be contextualized within the existing constitutional order. Now, for the transfer of charges and fines, they have to be put within the context of Article 24, rather Article 23 of the Constitution. And I will read Article 23 in comma. Article 23 4B, the 48-hour rule. That anybody whose rights are restrained, whose liberty is restrained, shall, if not earlier released, be brought to court as soon as possible. But in any case, not later than 48 hours from the time of his arrest. My lord, the Supreme Court decision should be read in that context. That actually the Supreme Court did not purport to overthrow the Constitution. They couldn't do so. So if the state wished to continue with the prosecution of those cases that hitherto were being handled by the General Court Martial, the time frame is set by the Constitution, 48 hours. And in lawful custody, I don't want to give them the advice, but if we were to go there, what I would do immediately, you would get them from prison within the 48 hours, take them to police, with police custody, because you will then be breaching Section 37 of the Prisons Act to keep them on remand without remand warrant. If I may ask my lord, the prosecution, I mean the state attorney is justifying the detention.
Are you asking the court so that they give you the answer?
Okay, let me give the answer here, my lord.
No, it is okay. You can ask and we frame it as a question.
Okay, let me frame it as a question, my lord. Are the applicants right now on remand? Are they on remand? Pending what charges? If they are in custody, pending fresh charges being preferred against them.
You have asked two questions in one. The first question is, are the applicants on remand right now?
Right now.
If so, what charges are they facing? So you continue. So that is
yes, what charges are they facing if they are on remand? And if I may add another question to that. If indeed they are awaiting transfer of their cases or charges for that matter, in the affidavit here they are indicating those charges, those matters are being handled by the DPP. And my learned colleagues here have cited Article 120 of the Constitution, which bars the DPP from sanctioning files before the General Court Martial. Has the DPP got anything to do with those charges, which were either being handled by the General Court Martial in the context of Article 120? Even if they were to be transferred, has the DPP got anything? And finally, still on that question, my lord, when you read the affidavit of Karemera, the Attorney General is simply saying that he wrote a letter to the DPP and the Minister of Defense. He is not indicating any action taken.
The question would be, is the Attorney General's letter
Yes.
the DPP indicating of any actions taken? Or does that letter indicate any actions taken? I want to record your question. Because I have to answer it.
Most obliged, my lord. Does it in any way address that? And in any case, my lord, in section 10, the Attorney General Karemera says the Attorney General's chambers forwarded the Chief Justice letter to Minister of Defense and the DPP advising that the files be forwarded to the principal judge. The Attorney General simply states that they acted as a conveyor belt. They received the letter from the principal judge, forwarded it.
Can you explain the question?
I wanted to advance an argument because this is my construction, my understanding of this.
Okay. The question would then be, was the Honorable Attorney General acting correctly to do ABCD? I don't want to
My lord,
Sir.
legally, I wanted to make but to advance an argument, my lord. Yes, because within the meaning of Act 120, the office of the DPP is independent of the administrative. Article 120, clause 6.
Is it the letter to the DPP evidence of illegal interference in the independence of the DPP? Is that what you want to do?
Not asking actually, the argument I'm advancing. And I want to conclude it by indicating to you, there is nothing on the record that shows that the DPP has taken any action. There is nothing. There is no record whatsoever that the DPP has taken any action under Act 100 in their evidence. That is one. Two.
On that one,
Yes.
supposing the DPP charges the applicants today.
No, my lord, the DPP had 48 hours
Okay,
within which to do that.
that was then.
Yes.
Supposing the DPP says, okay, now I want to do it today, and the charges any of these people, would your arguments change?
My lord, the application for habeas corpus is now being had and there is no charge by the DPP, and this is our contention.
No, but it's a supposition. Supposing the DPP charges the applicant, would the application stand?
With all due respect, my lord, I wouldn't want to venture into a matter which is now abstract, my lord. I must oblige, my lord. Related to that, there's nothing on record here regarding any action being taken by the Minister of Defense in response to paragraph 10, that the conveyor belt, that is the Attorney General, after relaying the communication from the Chief Justice.
Honorable Lord Mayor, why do you describe the office as a conveyor belt? Because conveyor belt is in a factory, so why?
And the government is a factory.
It's metaphorical, my lord. Most of that. Because the Attorney General's chambers forwarded the Chief Justice's letter to the Minister of Defense and the DPP as a courier. Now, not a conveyor belt. They acted as a courier. Yes.
Before they become a courier, we can use better words. They transmitted this information. They did letter.
Okay, let me say. They relay.
You know, I don't here, but to mark up even for the English language.
Most obliged, my lord. You will excuse me for my action, which not extend beyond what I have. Conveyor belt, and
You can use your colorful language there, simplify.
most of black demand. So, my Lord, after relaying this message, this communication, transmitting, actually, they just transmit the communication from the Chief Justice. After the transmission of that document, no evidence is shown that action was taken by the Minister of Defense. And they have the latitude of telling this honorable court that the process is ongoing.
You should be winding down.
My Lord, I'm concluding. And they are saying they are overwhelmed by work. This is the point I wanted to make. What work are they overwhelmed by? Because they are supposed to transmit the letter to the Minister of Defense and the Attorney and the DPP. So what work is it that they are doing? What is it that is overwhelming them? Because they are not involved in the process of the transfer of the funds. They have admitted on record. They are not involved. So what is it that they are doing which is overwhelming them? I submit that actually they are not involved. And I say that the court should not in any way, my Lord, continence in whatever they are doing, which violates Article 23. Whatever they needed to do in as far as transfer of charges, if any, should have been within the context.
I mean, there is no candidate involved in what they're doing. Yes. We had added on in this matter next week.
No, if they wanted to prove that there is any action being taken.
No, I just wanted to make sure the court is not casting bad light.
Most of that.
We cannot do the edges because we have scheduled this matter for next week on 25th. We had the energy, so to speak, really suggesting that we are interested in what we are still.
Most of that, my Lord. The final one, my Lord, is still on the legality of the detention. My Lord, it's our submission that once the Supreme Court quashed the proceedings of the General Court Martial, once those proceedings were quashed, the remand warrant had to fall by the wayside. And if at all it had been saved, like they have argued, it lapsed. My friend here said one of the other submitted. It lapsed on the 3rd of August. Brother, it expired on the 3rd of February. And to date, my Lord, it cannot just be
Resurrected.
Yes? It can't be resurrected. And the reason, and these prisons authorities who are here, they normally move with a document for extension. Do they have one? But they have it here which can be extended. And this honorable court, my Lord, cannot give them any remand warrant. I let it stop.
My Lord, if I
How many minutes?
I'll try to do it in maybe 10
is too much.
at the max. I'll try.
No, 5 minutes.
My Lord, they are again just two points. The first one, I would like to just draw the court's attention to. It's about the burden. And specifically, there are two sections, 103 and 106 of the Evidence Act that are important for the court to consider. The first one, 103, says that the burden of proof as to a particular fact lies on the person who wishes the court to believe in its existence, unless it is provided by any law that the proof of that fact shall lie in any particular person. So, in law, sometimes burdens are placed on particular people. But that's a general principle. 106 is more specific. In civil proceedings, when any fact is, especially within the knowledge of any person, the burden of proving that fact is upon that person. And that person, in this case, my lord, is the respondent or the respondent. The particular fact is the lawfulness of curtailing the liberty of his applicant. The respondents have pointed to the three ingredients. They say two are satisfied: the arrest of the applicant, the detention of the applicant. The third that we are addressing is the lawfulness. And so the evidence of the lawfulness is critical. And there is no evidence of that lawfulness. What we have been treated to in this application is a reference to a process that was stopped. At the stroke of a pen, that process ended. It stopped. It cannot be resurrected. That file cannot be restarted. It is non-existent. But that is the file that is being referred to as the basis upon which these two applicants are on remand. The second thing that the state has said is that we read the judgment, we are complying. And they have attached some documentation to suggest there is a process that is being undertaken. For my part, I will be grateful that indeed they are saying something is being done. The question is whether that thing which is being done means that the detention is lawful.
Okay,
no, it isn't.
Let's stop here for a while and I can take you on that.
Yes.
Supposing Mr. Karemera came here and said we have done nothing.
Yes.
Would your argument be the same?
My lord, to me, the argument is exactly the same. The compliance, the issue we are dealing with of personal liberty cannot be justified by administrative processes which have no time limit, which we do not know the details of. They can do those things while these people are enjoying their liberty. Because they can't demonstrate that they are being lost. So if it takes a month, or 6, or 2, or whatever it is, we are grateful that we are saying something. It's good. But it doesn't answer the question of whether this person is lawful. Now, my last friend suggested that the applicants are lawful. The only thing I can say is that we are in a place that is lawfully gazetted to keep guests of the state as in sometimes.
Maybe on that, the latest site, I think, is very English.
Yes.
Have a look at it and see the point and you counter. Because what seems to say, even when there are some problems, you cannot succeed easily under arrest. That's what you do.
My lord, I differ.
Yes. Now I want you to differ.
First of all, the facts that we're dealing with, I think, are different from the basis of the this decision. Under our law, what the respondent, and there are two of them here. The first one is the Attorney General who may not have direct engagement, but represents. The second one has actual knowledge because they are keeping
That's the commissioner.
the commissioner. The Commissioner General has said nothing in response to this application. And I'm not talking about the person of the Commissioner General, but reasons has said absolutely.
But at least they brought the so he has not done that.
They have said nothing about the lawfulness of the detention. My lord, it's important that we focus on the lawfulness because the lawfulness, in my opinion, comes out of three things. which they could have demonstrated if indeed they exist, but they can't demonstrate because those things don't exist. Is there a church anywhere which says they've been charged, they've been demanded? No, there isn't. Is there a warrant that remands them beyond the 3rd of February 2025? No, there isn't. That's why it hasn't been brought in. Is there any order of any court? That's the 3rd point. Any court anywhere, even if it was a male that says remand. My lord, there isn't. So when we go back to the burden of proof, that fact, that is especially within the knowledge of the respondents, the reason why these people are incarcerated, it has not been brought. You have been treated to the argument that we are doing the best we can. The best they can be done when these applicants are enjoying their liberty. That is what we have less focus application is about. The moment they can't demonstrate this fact, especially within their project, and Lord, we pray that you will persuade them to find that the 3rd point on which we agree with our land has not been. The affidavits are not been reading. They are averments with no attachments, saying something, but nothing is saying something. This matter would have been very easily dealt with if there was a court order, a demand order, or a charge. Simple as that. We wouldn't have said much. We would have just looked at it and said, oh, this is it. Okay. If it isn't there, my Lord, I implore you, let the Constitution prevail. The Constitution must prevail over every circumstance. Unless we have reached a point where we are saying it has no need.
But the Supreme Court actually made it so.
But I'm asking, my Lord,
Your argument is the
I'm asking respectfully.
maybe unless you are
This
the
court.
person of this court.
Yes, I'm pressing it directly.
The fact that we are here suggests that this court is present.
My Lord, I agree that with due respect, I am asking humbly, respectfully, that the Article 23 be allowed. Personal liberty is something that cannot be compared with anything else. Being incarcerated for lawful reason is terrifying enough. Being incarcerated for no reason at all has no place at all under this constitution. Unless we apply it, and we are not. My Lord, I rest by find our submissions in support of this application.
This even requires a detention order to be signed and sealed by a person authorized by law. So the question is, are these people being held? There is none. The word is under be detained for the next 1 hour? No. Finally, my Lord, we must not leave this kind of liberty to the detainer. The Constitution did not intend and did not give it. And who is currently the detainer? Currently the detainer is the learned Attorney General, Honorable Chiriwa Chwanuka, the Attorney General. Because he's the one telling these people, you can continue to detain. The detainer can only be court in a matter properly placed before court. the emphasis by my learned friend Amusugu that we have a justification and therefore sought to get solace in the decision of R versus Governor Supra by saying once they have what she called a substantive basis is a recipe for disaster. That once the state thinks they have a substantive basis, they can detain you forever. My Lord, even if the Attorney General saying they are concluding this process today or even tomorrow, the detention remains illegal. It has been brought to your attention, my Lord. No excuse of administrative processes can permit any further detention. I think they have even sought to intimidate you by saying the order you give might amount to contempt of court.
No, it is about intimidation.
Yes.
From your camp.
My Lord?
Even coming to my inbox,
For the record, my Lord, my camp is this court. My client is in prison. Unless you receive that message from his wife or child.
one message says my days are numbered. They don't see the light of tomorrow. But
I want to break that curse in Jesus' name. At least that you do not leave before you give us this good news. But on my part, my Lord, I can only say we have no camp. I represent none. Most appreciated. Most appreciated, my Lord. I'm only saying, Council Amusu said that if you give a decision as a prayer, it will amount to contempt of the Supreme Court. The Supreme Court has never made a decision of continued detention. If anything, like you did guide earlier, the Supreme Court restated and protected the Constitution. And that one is your solemn duty to protect the Constitution. We should come here equal before you and before the law. Here we are coming with a recalcitrant detainer saying as long as I have no decision of the Supreme Court to say release, I will detain.
that one is difficult. Can you split it down? I'm doing it deliberately so that if the tone is a bad one, then we'll be about it.
Of course, I must apologize, but not with this age. By the time I went to school, we were learning difficult words in the eyes of some, ears of some other people. But I want to say, you have a non-compliant and delinquent detainer who does not want to listen to the law, the command of the law. That's why I'm saying that this is a person who is maybe outside the court we would call it.
You can say it.
I'll use a smaller one.
Yeah.
What we are going to say outside is
Okay. In court, my lord, it is primitive arrogance for a detainer to say, I will not.
But I'll start from where my colleague stopped. We've dwelled so much on the administrative issues of the delinquent detainer. And my submission is that nothing done or supposedly done by the Attorney General, not even the DPP, constitutes justification for the applicant's detention. But for brevity, in as far as the misconceived submission of the Attorney General that the order of transfer can validate an expired warrant, the case for brevity that we refer to is McFoy, my lord, versus United Africa Company Limited. It's a New England Reports case, my lord, of 1961 in volume 3, which is very clear. If an act is void, then it is in law a nullity. It is not only bad, but incurably bad. There is no need for an order of the court to set it aside or even discuss it further. My lord, we shall supply this authority.
Okay, let me take you for the you don't need an order under this authority.
Yes. For setting aside, my lord, as they were taking us off the road. My lord. I'm justifying that the Attorney General has in a way succeeded into taking us into the administrative issues and their interpretation or misinterpretation of the orders of that court. My lord, going back to my earlier submission.
You requested for 1 minute.
1 minute, my lord. My lord, if you are to go back to Article 43, my lord, there is no, we emphasize, there is no trial in which a detention can stand. A transfer is not a trial. My lord, even the trial anticipated, actually impending transfer, which may take even a year. There is no such transfer even. There is no trial, my lord. Even the anticipated trial, my lord, is misconceived under Article 123B. They cannot take over anything from the court martial, my lord, as submitted earlier. So a transfer order cannot, my lord, be a basis for detention. The Attorney General dwelt so much on our submissions that we are reading into the orders of the Supreme Court. My lord, they are the ones actually who are reading deeper and outside the orders of the Supreme Court, my lord, by saying that the order of transfer validated that warrant. The Attorney General is misconceived and misrepresenting or misguiding this honorable court, my lord. But my lord, even if there was a transfer as submitted by the Attorney General, my lord, that transfer would be a transfer of file, not body. We are talking about a detained body. A transfer of files cannot relate to continuing detention of a body, the body that was brought before you. And they have failed, my lord, to justify the continued detention. That is why we are feeling hurt that even our client was being taken from this court by the prisons any further, probably now, back in New Zealand. My lord.
You don't have to be hurt as counsel.
My lord,
Okay.
I take your guidance.
I can guide you. We are told together, it's not your case.
I'm obliged.
It is the client's, so divorce yourself from the emotions.
My lord, when the law is being abused, but I'm obliged. Well, I'll emphasize, my lord, and we shall rest our case. The transfer is not on body. If there is any transfer or at all, is on file, not body. Rest our case, my lord.
Thank you very much. I think what is the Uganda Law Society? The one of the Mr. Kennedy. I thought it was the left to take advantage of the act and consolidate the application of
my lord, our issue comes in the timing of the ruling. If we are to file, because they look different, my lord.
Yes, my lord, with your permission, yes, whereas there could be some overlap, into the argument, mainly one overlap, that the General Court Martial was an illegal outfit. That is the only overlap. But because Counsel Kizza was convicted and the orders were being it has other links of the proceeding.
But the whole link, if you are saying you are convicted by an
Kata is here. Kata is here. We are closing the consolidation. Kata is here.
Yes, my lord, I appear in the kizza, Aaron kizza application.
Mr. Wadini also told us that we can accord him the respect that he sits.
Have a seat.
Yes.
I was dealing with
He's not here, my lord.
no, he's there. Why is he here? The one who was the bundle is start in the bundle. Mr. Wadini can guide us later. Because now, Mr. Wadini will debate me. No, my lord. You are still on the children's
We received the application when we were working on when we were president. So we have not tried it. And my instruction is that how we stand up so that we can survive.
and for me, as you think about complying, this is the mind I form because I read the motion and I have seen in the principle of this is the power of an unexistent force to man or even to pass it.
That's one leap.
The only thing that comes out is the lawyer who wants to chat with the court and etc. But the whole question is there.
No. My lord, with your permission, with consultation with my colleagues, my lord, there is a second limb which is equally important. The process. That even if you said it had the powers there, and how about the process? The impropriety.
We agree as
Yes. Yes, my lord. No, my lord. No. Supposing I want to mitigate.
On that one, I'm going to ask for, let me give direction.
If I may, I have discussed with the council and he's in agreement that we can stand for up to here, stand here.
For me, I wanted to give you all direction. Instead of standing up, I am Kadera Shari and we have so I just wanted to give direction. That AG applies the most by every other person should find this issue like one. Then, so that way, it will save me my former teachers. But I'm saying this most
And in the meantime,
I know, yeah, the direction is you have not, AD has not been asked. But they have been served. But the idea is there. It's up to you to reply. Up to 5 years. By then, you can enjoy it. Then all of you 5 year advance. Now for me, I'm giving you a hint. That I'm right there. If I choose to consolidate, I
May not maybe if I may, just to make sure that the vote does not make a mistake. And the matter involved in the meantime, quite
am a decision to consolidate because I cannot consolidate that.
we did it for this.
But I am not.
I think, my lord, we have a win-win with your guidance, for which I'm grateful. And I'm about to propose as a win-win. It is not rocket science, it's something which I've done before. First, we would be comfortable with all parties exchanging feelings calmly, provided in the meantime you grant an interim order of release. But Lord, you need to listen to my prayer. I'm grateful.
My lord, I was only helping them to be able to come here. They have effective.
For me, I care whether people threaten you. Even when I saw that letter which has been circulating, I was concerned. Yes. So for me, that's what I said when I don't want to let's not allow them to speak. The head should reply by fire.
Before the directions are given, these are draft directions. We shall amend. Just on the procedure matter, my lord. My lord, if I may. First of all, Lord Mayor, I gave you most of that. So, then he should reply by non-judicial. That's what he said. Yeah, that's for what? The AG is the civil servant like for us.
It's a very huge office with many lawyers.
So by tomorrow night, you can rejoin. Now,
my lord, can I suggest that the file and serve us by close of business today?
Yes, yes.
Your Lordship, I've just been informed by that my friend and brother has 4 applications. And as of now, as far as I'm concerned, we have only received 1 application. And he has informed me that allegedly others are coming. I will take them on now. Your Lordship, for applications that we have not received, how do we respond to them by process? If there is no application, how can you provide it that there is an application? That's what he said. So that's what we have to
deal with what is before court.
No, my lord, all 5 applications will be served immediately after court, so that they have opportunity to reply by 5 o'clock and serve us.
I'm sure they've been
now, let me listen to Lord Mayor.
Issues, my lord, matters of concern. Personally, I'm really concerned about the procedure now we are taking. The matters involving the habeas corpus. It's, my lord, understanding of this read, it's a prerogative read. And the prerogative read of this letter which touches civil liberty. It's interrogative. And
that's what I'm doing.
Yes, exactly. So if you need to go into these matters, to summon the Attorney General, to summon the Commissioner, to come and show cause, you can't show cause by way of written submissions. If you adopt the written submissions, it will be prejudicial to the applicants in that, at times, my lord, we go out of outside the pleadings when you are interrogating matters with it. My lord, it is allowed with issues to do with an interrogation. Because it's an interrogation, my lord.
That's how I understand.
No, my lord, what I'm saying here, once court summons the authorities detaining the applicant, please bring the corpus, bring this person here. Court has to pose questions. All questions emerge in the court, like it has happened today, my lord. So if it is by way of written submission, my lord, there are issues that will not be canvassed, and that is my concern. Yes.
I had one direction, but I detected I would be misunderstood. So I allowed it. So let's go back to what I had planned for. Number one, all the pleadings should be served by close of business today. Reply should be given. All the parties should write as many words as they want. I'm not going to limit. I normally limit by end of business tomorrow. So that gives me time. Me, I'm not going to sleep. I will start drafting a decision today.
What I was raising here, I'm sorry to keep insisting. Like we are earlier on saying that it's a two-pronged matter when you talk about habeas corpus. First produce the body, and the body is here. Now the question is to interrogate why that body is detained.
Now interrogate it in the arguments.
That's difficult, my lord. Written submissions, arguments and counter-arguments.
I am lucky, I have two teachers here. And they will look at me whether I understand what they want to be. If I come to think that it's not possible, they told me to know that it's possible.
Interrogate in writing.
Yes, they told me. Thank you very much. Now, I
And then the
continue.
consolidation, my lord.
Because the consolidation, because I picked it up, in your arguments you can say it is wrong to consolidate. Someone can say it is okay to consolidate. A decision will be made on consolidation. I was just throwing an idea. So thank you very much.
Maybe for clarification, is that the submissions are for every case.
Yes.
You also made a note that service is being effective for any application which are not served. Now I'm looking at this scenario because you see that we have
May not just to clarify, as I indicated, the matters that were there are two applications, every kizza versus commission and attorney case. And that's the one which Mr. Peter is prosecuting. Then, there is the Ghana Society versus attorney case. That's what he's talking about it. My understanding is all the applications that touching everything that matters are going to be served with them. Then they respond, and then we will join, and then that's
The pressure you should put on the judge is that we finished all the things that when it's our decision. Me, I'm not going to see that's what I'm doing. So thank you very much for
So when we come,
My lord, Jude, you have something important. Such an application needs attention.
now how am I going to give the date when
no, but not one of the applications they have the corpus, which needs to be submitted determined.
unless you want me to report to you, we have given
I've already reported him.
But my lord,
But
in this matter where the submission is yes.
When?
Our concern was that my road. Without consolidation. Because my Lord, you saw what and he has no what do we do with this exposure now?
I'll take you next Saturday, Tuesday.
Italy, at night. Where the applications is served at meetings now? If you have had something.
They have been served. They are served
Thank you.